Good afternoon, everyone. This is Steve Sandherr with AGC of America, and I'm welcoming you to our webinar this afternoon on the latest developments on the coronavirus and what that means for the construction industry. I have with me from a number of remote locations some staff colleagues who will help me with this presentation today, and I will introduce them as their turn comes in the presentation. But at the outset, let me handle one piece of housekeeping. This webinar is being recorded and will be shared with you soon after the webinar ends. So obviously, we have been extremely busy at AGC this week trying to deal with all of the ramifications of the pandemic that we are experiencing. And just as healthcare professionals have to engage in triage, we are trying to do the same. And in doing so, we are looking at basically four priorities. The first is, what can we do to help keep AGC member firms continue to work? What can we do to keep the government at all levels from hurting you? How do we educate members of Congress and the administration to find ways to be of assistance? And then finally, how do we provide you with the information you need to keep your employees safe, keep your doors open, and protect against future losses? So we are going to attempt to do that perhaps from a 30,000-foot level in this webinar. But at the end of these proceedings, we will be announcing a series of webinars to be held over the next 2 weeks that will go into further depth on the topics that we are addressing today. And at the outset, I would also like to thank AGC members for their assistance in two main areas over the last week. The first is we put out on Monday and Tuesday a survey asking members to respond on how the coronavirus is impacting them. And your response has been overwhelming. You have given us a lot of data to use to help tell our story as we deal with policymakers. And secondly, member firms have also exceeded our expectations in our legislative alerts, where we've asked you to contact members of Congress. We'll get into more detail on that later, but I can tell you on the paid leave issue, we received more emails to Congress on that single issue in about a 36-hour period than we typically receive in an entire year over a multitude of issues. So thank you very much for stepping up and helping us in that regard as well. So obviously the first area we're going to discuss is what you've told us in that survey, and I'm going to turn it over to AGC's chief economist, Ken Simonson. Ken?
Thank you, Steve. The survey was open for about 48 hours, and we got 909 responses. So if you were among them, thank you very much. And we will be posting another survey next week covering much of the same ground, but we would welcome you coming back in, particularly if you have more information to contribute. The key question for me was, have you experienced has any government agency or official directed you to halt or delay work on any projects that are either active or expected to start within the next 30 days? And more than a quarter of the respondents, 28% to be exact, said yes, that had already happened. 11% said that they were running into that issue with projects that they were expecting would start more than 30 days out. So we asked about what had caused delays or disruptions, and 16% cited shortages of materials equipment, including personal protective equipment for their own workers, such as respirators or parts. 11% said that there were problems getting craft workers on site, including those of their subs. And 18% reported shortage of government workers or closure of government offices, so they weren't able to have timely permit approvals or inspections, other steps necessary to keep a construction project on track. Fortunately, only 8% said that they had had an infected individual on the job site or in a way that potentially infected the job site. And then finally, 22% said that suppliers had sent a notice that deliveries would be late or canceled. So these are early results. I'm afraid that all of them are likely to show up in a greater degree, and we will keep polling about that. In terms of the economic impacts on construction, I guess my top line answer is that the industry has not been affected as immediately as, say, cruise ships, airlines, hotels, and more recently restaurants and other gathering places, certainly sporting venues. And I do expect that the bulk of construction projects will continue as long as government agencies in that jurisdiction are allowing work to continue, owners are allowing contractors on site, and the workers and materials and inspectors and others are still coming. So far, the number of agencies or owners that have prohibited construction remains very small, but more and more are starting to adopt that. Just for a very quick short list, we know cities of Boston and Cambridge, Massachusetts have prohibited construction among many other activities. The governor of Pennsylvania, initially it looked as if California last night, the governor was going to block that, but within an hour or two, AGC of California was able to get clarification, modification of the governor's order that exempts construction. So we will continue to be working hard at the state, local, and federal level to clarify and, wherever possible, allow construction to continue. But nevertheless, it's clear that there will be selective disruptions. Another worry is owners that run into their own financial difficulties or just operational difficulties of getting someone to authorize payment and send it out. So contractors may not be getting paid on a timely schedule, and that clearly has ripple effects throughout the industry. Going forward, we expect more and more owners are going to be deferring the start of projects that you may have expected would be happening very soon. And you may also have a lot of trouble getting firm delivery time commitments and approvals out of government agencies. On the positive side, there are likely to be, have been already, a few examples of projects added. A few might be greenfield ground-up projects. More likely, I think it's going to be very quick remodeling, repurposing of existing structures, additions to enable hospitals to handle more patients, either the ones with coronavirus or to move other patients away from areas that they'll be dealing with these infected patients. Also, lodging for people who have been displaced or are homeless, and manufacturing and testing facilities may be adding capacity on a very short basis. The most dramatic effect we've seen so far may have been in a huge drop in crude oil prices. I was looking just before the close, and West Texas Intermediate down in the low 20s. That's a drop of about 60-some% from a high point just a few months ago. And basically it means about $1 a gallon drop in diesel fuel and gasoline if it all carries through. Other commodities such as steel, copper, aluminum, price drops also likely for the near term. Looking into the longer term, I think that construction will be one of the slower sectors to rebound, as it will take owners a longer time to either have the confidence that the facilities that they had thought they needed would be needed, or that they would have the cash available to pay for construction. And we also expect that many public budgets are taking a very severe hit. Certainly, all the public transit agencies have been reporting enormous drops in ridership. Airport authorities, which have been going full tilt all over the country, all of a sudden they're not getting any of their normal revenue sources. And a wide variety of other public agencies are seeing drops in general fund revenues or dedicated revenues, such as gas tax receipts to pay for highway projects. Sadly, we'll also be hearing about construction firms that weren't able to handle the reduction in business and may not have been paid in time to keep their doors open. And I think that for the long term, we may see, at least the medium term, less demand for new office construction, lodging, perhaps large sports and entertainment facilities of various types. One positive for the longer term, I think commodity prices will be much slower in coming back to where they were 3 months ago than it looked like at the beginning of the year. So with that, let me turn it back to you, Steve.
Thank you, Ken. So now I'm going to turn it over to Jimmy Christianson, our Vice President for Government Relations, with the notice that Jimmy and his team have been literally operating around the clock for the last week, trying to put out fires and try to encourage Congress to do the right thing by our industry on a number of topics. So I'll let Jimmy go into some detail on some of those issues. Jimmy?
Thanks, Steve. Yes, it's been a long week. I'm going to start quickly by going through just a little recap of what's happened in Congress over the last week and a half or two. Talk about what passed on Wednesday as far as the various paid leave mandates. Talk about how we sought to impact that legislation and what sort of small improvements we were able to make to help make things a little bit better. Obviously, we want it to be even better for you all. And now that has become the law, also seeking ways to address it and deal with other things as far as ensuring that your companies have access to loans, cash flow through various federal infrastructure funds, as well as setting the stage for long-term infrastructure investments through reauthorizations of various federal and federal aid programs. So let's talk about what's happening in Congress right now and has been happening. First, we had an $8.3 billion spending bill signed into law on March 6th. That dealt with mostly getting tests, medical supplies, and other emergency response folks paid and into the field. Phase 2 was what we saw on Wednesday, which included additional funds for those items, as well as the paid sick leave and paid family medical leave that we'll talk a little bit more about. Currently, we are working on about a $1 trillion business relief package that will also not only include relief for many of you that are on this line, also direct federal checks for many people throughout the country. The question we have is whether, in addition to those things, whether there'll be any sort of additional cash infusions into federal construction accounts, like the Highway Trust Fund, the state and the Clean Water and Safe Water Drinking revolving loan funds, just as some examples, as well as the Army Corps Civil Works and military construction accounts. And then we're also looking at fixes for multi-employer pension plans and health plans that are very stressed under the circumstances.
Jimmy,
question is...
Sorry, Jimmy, before you go to phase 4, and phase 3, which is the current phase that we're Can you briefly describe the unorthodox way in which this legislation, which is likely to be north of $1 trillion, the unorthodox manner in which Congress is legislating here?
I think I've told my staff and told everybody this multiple times. They've probably heard me say this. The rules don't count. What we used to think went on Friday doesn't matter anymore. We are literally throwing spaghetti against the wall and seeing what sticks. Congress is literally writing things furiously and worrying about the consequences later. Fiscal conservatism, all these sorts of things don't really matter. Most people are just focused on making sure the house doesn't burn down. So it has been around the clock in trying to make sure that our industry is involved in whatever is going on, not just to get the fair share our industry deserves as a result of all delays and shutdowns and slowdowns, but also the fact that they are looking to do things that are even broader than just the immediate term.
Okay, thank you. Sorry to interrupt.
No.
And then what's
let's
phase
talk
4?
About phase 4. We will, we'll see if there'll be another round where they'll take a look at some other items like infrastructure, like multi-employer pensions. With the Republican Senate in session now, they're kind of leading the charge on phase 3. The question remains with House Democrats if they'll come back into session at some time to deal with phase 4, and which we are thinking would be right for infrastructure and pension reform and healthcare plans as well, among many, many other things. Also looking for opportunities to fix these paid leave mandates even further than we were able to do in the first place. To that effect, there are new mandates in place. They're coming fast and furious. They apply to employers with fewer than 500 employees. The Secretary of Labor has the authority to exempt small businesses with fewer than 50 employees from both provisions. So AGC will be sending word to the Secretary of Labor of our strong support for those exemptions. These provisions take effect on April 2nd of this year, and they sunset on the 31st, and both are paid in quotation marks with tax credits, which we'll talk a little bit about. And then obviously AGC represents both sides of the house, both open shop and union contractors. And as far as the applicability on existing collective bargaining agreements, I have an esteemed labor lawyer in our general counsel, Mike Kennedy. So Mike, would you just be able to mention how these apply to the union contractors and collective bargaining agreements?
Thank you, Jimmy. I don't want to pretend that I can say anything definitive, but I have taken a hard look at the language in the statute. And for me, the most natural reading of the statute is that it does apply to union contractors, including those working under multi-employer agreements. It does, however, give them the option of negotiating a multi-employer plan with the trades and contributing to that plan, and assuming that the plan meets the parameters of the statute, that will substitute for their individual compliance. So they are covered, but they do have the option of negotiating a multi-employer plan that would relieve them of their individual obligations as long as they make contributions.
Thanks, Mike. And let's talk a little bit about the paid sick leave mandate first. Again, this one applies for those companies that are applicable with fewer than 500 employees. Applies to all employees, regardless of how long they've been employed, for the 6 reasons that you see. depending upon which numbered reason you see under the qualifying reasons for leave. That will help determine what the capped rate of pay is that the employer will have to pay their employees for that leave. And this is for 2 weeks, so 80 hours of paid leave. The number of hours for part-time employees works on the average over a 2-week period. And so you could see here, obviously there's some issues with how can you determine if an employee is caring for an individual who is subject to a quarantine or caring for children necessarily, but versus experiencing symptoms of COVID-19 and seeking a medical diagnosis. These are really going to be situations that will be difficult to prove or disprove, and really give everybody some cause for concern there. And we'll talk a little bit more later about this payroll tax credit. Scrolling down. On the paid leave side, this again applies, as opposed to the sick leave, it applies to employees who have been employed for at least 30 days. So not all employees, those that have been employed for at least 30 days. This is up to 12 weeks of leave related to an emergency related to the virus. There were 3 different reasons qualifying for this leave. We were successful in getting it narrowed down to 1. We made sure we sought that it wasn't 12 weeks of fully paid leave. It's only 10 of the 12, but you can take existing leave towards the 12 or take unpaid leave for those remaining 2 weeks and still come back to your job. The issue with both of these provisions that everyone is concerned about are tax credits. As you all well know, if money is not coming in, you will not have taxable income for which to receive tax credits back on. That is the big question, is cash flow, cash flow, cash flow, and how will we be able to make it those 12 weeks? In the discussions that are literally ongoing to our knowledge in the last several hours, the Secretary of the Treasury, the Majority Leader of the Senate, and Speaker Pelosi are talking about ways to speed that up and perhaps find a way to advance those credits. The question is, this is unprecedented, and will it be enough, and will it be in time? We still don't know, and that's why we did not want employers to be fronting this. Our position all along has been that the federal government is better equipped to deal with this, especially in a situation that has been unforeseen and businesses have not been able to prepare for. And as a result, we were calling for a program to either be run through the Social Security Administration, or we worked with Senator Ron Johnson on pushing an amendment through a process that would pay people via unemployment insurance. Unfortunately, that did not take hold. Needless to say, we still garnered a lot of support from you all out in the field, and appreciate that. Some considerations you should give while you look at these credits is you can also claim credit for qualified health plan expenses. You can draw upon your payroll escrow accounts to pay salary and benefits without penalty, and your paid leave and FLMA, your paid sick leave and FLMA leave is not subject to Social Security and 50% of the Medicare tax withholding. These are ways that you can remain fluid and keep going and paying your employees under these mandates, and hopefully to continue operations as uninterrupted as possible. Obviously, again, there's causes for concern. We've already talked about waiting to be reimbursed from Treasury, our cash flow issues, mentioned the fact that we you're going to have difficulties determining who's telling you which reason in order to get paid more for their paid leave. So you got to be careful with that. And just unfortunately, you have to remember that as far as this is concerned at this moment, these paid leave mandates are in addition to existing leave mandates at state and local levels. And one of the big things we will be looking to do is make these paid leave requirements, at least while they are in effect, preempt the state and local requirements, so you have one set of requirements and or seek opportunities for waivers or further exemptions from those state and local requirements. Again, mentioned some improvements. Again, the allowing the secretary or authorizing the secretary to exempt employers of under 50 employees. That's a big one for our small business members. In addition, you'll have to remember that on the paid sick leave side, you will be able to adjust if your company already gives paid sick leave that's not government mandated, whether it's through a state or local law or regulation or ordinance. You can adjust your paid sick leave with the new additional mandates at any time, so that people don't now get perhaps 4 weeks of paid sick leave. In addition, as we mentioned, we narrowed the expansive instances of employees to be eligible for those 12 weeks of family and medical leave now to 1. So that at least
Jimmy,
smooths off the edges. Yeah.
I'm going to ask a question that we got in the last webinar. Do individual employers need to seek the exemption from the Secretary of Labor for the 50 employer under exemption?
We do not believe that is to be the case. That would be unwieldy and impossible to be done in anyone's mind. There's just way too many small businesses, and there's not enough people, especially in the government right now, to determine that. So more than likely, we'll see guidance from the secretary or some sort of decree, hopefully making that announcement. And again, that will be something that AGC of America will be urging the secretary to do very strongly.
Thank you.
So we, as Steve had mentioned, we saw significant numbers in our action center with members taking action. It helped make a difference. It really got these members of Congress talking to us, listening to us, and finding ways as to how they can maintain our cash flows, continue our markets, from dollars flowing to them, and then looking for a way to lay the foundation for a long-term recovery. So I can say that I just checked the numbers before. We currently have up the Protect Construction Jobs and Markets now. It has been 24 hours and almost 16,000 messages have been sent, I believe. We're close to 30,000 messages sent to Congress in the last 3.5 days, 4 days. That is unheard of in my nearly a decade with AGC, and we're asking you to continue to pound the members of Congress with these action alerts to let them know where you stand, because they need to know it's making a difference, and it's really important to send it out to not just you but your employees, so that we can continue to get traction. It's not just on these action alerts that we need your help. We need your help with your data to help Ken and Brian Trammell and others on the communication side as well. Get that out to the media, so that it's another way to get the government to take action. But we're using that literally in our meetings with the majority leader and other House and Senate leaders and key members of Congress in pushing forth our efforts to underscore the reasons why the construction industry needs to keep going throughout this emergency, throughout this pandemic. So please keep responding to those surveys as well. It is absolutely critical, as we are finding the industries that can provide data are getting provided the funding that they need. That's all from me at this point. Steve, I'll kick it back to you.
All right. Thank you, Jimmy. And thanks to you and all your colleagues for all your hard work. So Kevin Cannon, our Senior Director for Safety and Health Services, will update us on what we've been doing on not only communicating with OSHA and the Department of Labor, but also what resources we've put on our coronavirus web page or microsite. Kevin, take it away.
Thanks, Steve. One of our initial concerns was how we as AGC were going to assist members with protecting their employees, but also how the federal government would respond. And in this case, it would be OSHA as it relates to workplace exposures of COVID-19. So we have been monitoring what the agencies doing and what resources that they've made available. And one of the initial things that they did was put out guidance on recording workplace exposures to COVID-19. And I'll say that that guidance was very broad and general in nature, and gave the appearance that any case that popped up on your job site, or excuse me, or an employee had contracted the illness, then that would be work related. However, with AGC's intervention, and specifically a call between Secretary Scalia and you, Steve, where you highlighted the concerns of AGC members, as well as the potential negative impacts of such a broad policy or guidance would have on future work. They did issue a revised set of guidance on Friday, March 13th. And in that guidance, they kind of clarified that it would have to be a confirmed case of COVID-19. It would have to be work-related and meet the general recording criteria, such as medical treatment beyond first aid, or, days away from work. And what they did make clear is that in their guidance and their existing record-keeping regulation, if there's no evidence that the employee contracted the virus in the workplace, then it's not a recordable illness. And based on those conversations and some work here that we did internally, we put together a document to help members navigate the process of determining whether a case is work-related or not. The other thing that the agency did was prepare a document on COVID-19, trying to assist employers with getting ready to respond. And some of the highlights in that are steps the employers can take to reduce workers' exposures to COVID-19, and then classify worker exposures based on risk categories. And it goes from very high risk, which are typically your healthcare providers, to medium and low risk, which is where we believe that construction workers fall, and how to protect those workers. The other thing they did was created a safety and health topics page, and really that's a page with your background information on COVID-19, but it links to the relevant OSHA standards that may be applicable, such as personal protective equipment, general environmental controls, and toxic and hazardous substances. And what did AGC do? Well, we felt like it was necessary for us to put together a resource for members, which would essentially be a one-stop shop where you could get, all the latest information from, say, CDC, HHS, DOL, and any other federal agency that's responding or issuing guidance on this particular outbreak or pandemic. And on our page, we have background info, sort of what is COVID-19, what are the symptoms, tips for employers, and one of the tips is cleaning, sanitizing, and disinfecting guidance from CDC, EPA, Department of Labor, as well as one of our tool manufacturing partners. But on that page, there's also resources on recommended practices for construction job sites created by AGC of Houston, Oregon, Columbia chapter, the Builders Association, and a toolbox talk created by AGC of Washington. One of the things that we've heard from members or questions we're getting is, how do I respond in the event, we do have someone infected on the job site. So we're currently putting together a sheet or a document that highlights tips for prevention, but also tips for response, including how contractors should or must investigate any reports. We'll continue to add more resources to the page as they become available. So I encourage you all to check back. But even if you haven't been to the page, I would encourage you to do so, because it contains a lot more than what I just covered here. And you can find the link here on this slide.
Okay. Thank you, Kevin. Let's switch gears for a second and talk about contractual protections for contractors as they are dealing with owners. And I'd like to turn it over now to Brian Perlberg, our Senior Counsel for Construction Law and Contracts. Brian?
Thank you, Steve. Hello, everyone. So I guess they saved the lawyers for the last part of the conversation for the presentation today, because they know that we would keep you on your toes. So before I get into the meat of my presentation, let me just begin by saying, pardon me for I'm about to speak French, because coronavirus is a force majeure event. Force majeure, and this is really why we write contracts, to try to address things like this. Force majeure is not something from Latin, it's not from common law, but it's something we put in our contracts because we know there's going to be sometimes unforeseeable events that are going to make it impossible, or more likely for us to prove impractical and not practical to perform. So when you're in that situation, you need to show that it was, one, not contemplated, and that it caused your delay. Typically, when we look at our contracts, you are usually able to get time, an adjustment and remedy for additional time to address the delays. And this started with coronavirus, with delays in the supply chain. The $64,000 question is going to be, will you be able to get money for this? Now, one of the things that you want to do when you're looking at this, the first thing to do is you need to read the contract. One of the things I like to say, when you're a general contractor, you can't say the word general contractor without saying the word contract. So one of the things you want to do is look at what the standard contracts. Maybe you are working under a standard construction contract. The American Institute of Architects, A201, the AIA A201, has a provision. It doesn't say force majeure, but there is a delay clause at 8.3, which would give you a time extension for things beyond your control, ... as determined by the architect. So you need to give notice, and you need to make sure that that notice, the reason for the delay, is approved by the architect. And so what you need to do is, again, to give timely notice, and we're going to jump into that a little bit second. Now, on consensus stacks is a coalition effort that includes 40 groups, that certainly includes AGC. And we also, that's what I do every day, is work on consensus stacks. We specifically mention epidemics in the provision that is on your screen at 6.3. It also mentions adverse governmental actions. Having the word epidemics or pandemics or quarantines in your force majeure provision is going to be a lot better for you to demonstrate that what we're going through now is a cause for your delay. In certain states, like I've read some case law in New York, you may be prevented from pointing to a force majeure clause if you don't specifically have something like epidemics and pandemics. So if I were in New York, I wouldn't want to be working under an AIA contract document provisions. I'd much rather have the consensus docs. And that's one of the things when we look forward to reviewing your contracts, you want to make sure that you review your force majeure clause. Usually I reserve my speaking French when I am commenting on the AIA documents. Now, what do we want to do proactively here? Because that's really what we want to give you practical advice. Well, you got to give notice. Kevin mentioned that we have a COVID-19 website. I just yesterday put on a great sample notice letter, because you want to give prompt notice, because if you don't, you may lose your contractual remedies. But if you put too much in that notice, you might box yourself in. So you want to give the notice, you want to give it in writing, but the facts on the grounds are changing so much. For instance, with all the government shutdowns, you might have said, well, I am delayed because of a force majeure event because my supply chain is backed up. Well, now if the government stops work on your site because of an adverse government action, maybe you've boxed yourself in. So the sample letter, which is at the bottom of the page under contracts, contract information, gives you some great sample language to consider. So the other thing is what you want to do is you want to be able to record facts that you're documenting as to how much the delay is and what are the costs involved. Those are things that you might not have to give immediately, but it's something that you and your field folks want to start organizing and recording. Now, going forward, I want you to look at your contracts and think about this. Force majeure requires an unforeseeable event that is not your fault, right? It's sort of like that little scene from Good Will Hunting where Robin Williams tells him it's not your fault. Well, it also has to be unforeseeable. And in this case, you know what is foreseeable is things like coronavirus. So you need to have a broader force majeure clause going forward, and you want to use other provisions to help proactively address the risk and volatility that we're going to see. One step that you can take is include an escalation clause in your contracts. That's good for the owners too. We're going to have a lot of volatility. You don't want the owners to overpay for materials that you have to price in, and then it turns out that you are able to actually get better prices. So if you have something like the consensus stocks 200.1, that is something that will adjust for indexes that are objective. And what I would suggest to you is to consider other, modifying that to include potentially labor costs. Now, I'm gonna hand it back to Steve in a second, but I will tell you that there are much more contractual and construction law issues that you want to include to consider, such as your emergency and safety provision. You might want to be looking at what if the owner suspends for 30 days? What if you look at your change of law provisions? These are things that we're going to be able to drill down much more in a webinar series that, let me hand it back to Steve to have Mike Kennedy kind of give you a preview of that.
Okay. Thank you, Brian. Mike Kennedy, you have been busy dealing with a lot of folks here internally on developing a series of more in-depth topical discussions about the impact of the coronavirus on the construction industry. How about previewing what you've got planned for next week and the week after?
Well, thank you, Steve, and welcome everyone. Good afternoon. Obviously, in a 1 hour or even a 2 hour webinar, it's not possible to drill into all the questions that contractors need to explore. We're pleased to have this opportunity to give you an overview, but we realize it's not going to be enough. We have therefore planned an 8-part webinar series that will begin on Monday of next week and run through the following Wednesday. Each of these webinars will be somewhere between 60 and 90 minutes, and each one will begin at 2 p.m. Eastern Time. As we work through these webinars, I'm looking at your questions as they come in. Yes, you have stumped at least me at least a dozen times. We hope to have more time then to drill down deeper and answer the questions that many of you are raising today. The first webinar on Monday, March 23, will take a deep dive into paid and unpaid leave. During that session, we'll cover not only the new federal legislation, but we'll also set the stage by talking about the current FMLA requirements and about some of the federal requirements for federal contractors, the contractual ones. We'll also generically touch on state and local statutes and ordinances that may also require either paid or unpaid leave. On Tuesday, we're going to take a deeper dive into the many federal and state employment laws that could apply in ways you do not expect. One comes to mind is the National Labor Relations Act. If you're an open shop contractor working in a non-union environment, You're probably not spending a lot of time thinking about the NLRA. The fact remains that your employees do have rights under that statute that you need to be aware of and sensitive to. We're also going to touch on the Federal Labor Standards Act, the Americans with Disabilities Act, and other things that are going to be coming to you as this outbreak unfolds. On Wednesday, we're going to bring back Brian Perlberg and a couple of outside attorneys to take a harder look at your contractual and related legal protections and risks. Brian mentioned several of the contractual provisions that you need to take into account. It is important to understand what you need to do in terms of notice, documentation requirements. You need to be prepared to protect yourself. Obviously, you don't want to get into a confrontational situation with owners. It's much better to have open conversation and work things out, but you do need to know the legal framework that you're beginning with. On Thursday, we're going to bring back Kevin Cannon, and we're going to take a deeper dive into what is necessary to protect both your own people and everyone else on your job sites. We're going to be looking at the steps you can take to mitigate the risk that the infection will hit one of your people or one of your subcontractors' employees. We're also going to talk a little bit about how much protection is enough. The short answer is it's very vague right now. We can't tell you with certainty, but you should know that it's important to do whatever you can. And for political reasons that Steve may touch on later, it's important for the world to know that the construction industry is capable of protecting its employees and that we're out there doing everything we can. On Friday, we're going to talk about project continuity. How do you keep a project moving in this particular environment? What are the many things that could cause a delay or a disruption? How do you minimize the risk of those things occurring? How do you shorten the time of any disruption that you experience? We're going to pull together people and talk about practical strategies that contractors have developed or are now in the process of developing. On Monday of the following week, we change gears and we turn to insurance coverage. There may be sources of insurance coverage for some of the losses that you experience. That it could be your professional or a pollution liability policy. It could be your builder's risk policy. We're also going to talk about commercial general liability. What pockets of potential risk management do you have there, and what kind of documentation do you need? On Tuesday of the following week, we're going to turn to information technology. The truth is that the current environment and the way people are working is putting a lot of stress on construction contractors, information technology systems, and on the people who use those systems. And I need to share that the people interested in attacking your systems are well aware of this, and they're looking for vulnerabilities. So if you have them, if your people have not been fully trained, if they're not on their toes, this is the time you could actually experience that attack that government and other officials have been warning about for a long time. And last, on Wednesday, April 1st, we're going to bring back Ken Simonson, Steve Sandherr, and others to take a look at what lies down the road. We're not going to try to get too far ahead of ourselves, but what are the leading economic indicators that we need to be watching for the next 4 to 8 weeks, maybe 12 weeks? How will we know whether things are getting better or worse? And what is Washington likely to do? We know what Congress has been doing up to this point. What is the thinking in the White House? What is the thinking on the Hill? What can you reasonably expect? Again, what should you be looking for? So we hope you have an opportunity to sign up for these webinars. Again, they will start at 2 p.m. Every afternoon for 10 days, 10 business days, beginning on next Monday. Also, while I have just 1 second, I want to encourage all of you to participate in the survey that AGC sent out this week. We're going to do it on a weekly basis, and I got that question from someone while the webinar was continuing. We hope to develop trend lines. So it's important for us to thank everyone who participated this week, and just as important for everyone to participate again next week. We're trying to plot the direction of this problem for the industry. And last, the coronavirus website that Kevin Cannon mentioned is something that is constantly growing and expanding and evolving. Yes, we have a great deal of information on there on how to protect your people, but we're adding additional information all the time on insurance coverage, on contractual issues. That is going to be a place you can go to and find, we hope, just about everything you need. That's all I've got today. Steve, thank you so much.
Thanks, Mike. And to further that point, all of these 8 topics that will be discussed in webinars over the next 2 weeks, those will be recorded and those will be posted on our website. So if you can't, for some reason, participate at 2 p.m. Eastern Time on the days of the topics that you want more information on that same day following the webinar, they will be posted on our website. So let's turn to some of the questions that have come in, and I've been taking a peek at them, and there's a lot of questions, just like there were in the first webinar that we did today, and a lot of them dealing with the paid the paid sick leave and paid family leave, and how it impacts collective bargaining contractors. And I think our initial reaction to a lot of these questions are, we don't know yet. And while I was thinking about this, one question came to my own mind about this, and I'm going to see if Mike wants to take a stab at it. So you're a contractor with union agreements. The federal government just has told you that you have to implement these paid sick leave and paid family leave requirements. And if you implement them, are you running the risk that your signatory union will file an unfair labor practice for not bargaining in good faith, because these are mandatory subjects of bargaining?
Well, you stumped me again.
Yeah.
Well, you stumped me again, and I expected it. The short answer is we haven't run that to ground. My initial reaction, and it's nothing but an initial reaction, is that the later enacted statute, in this case, the Emergency Relief Act, would take precedence over the National Labor Relations Act, and that contractors would have to comply, and it certainly should not be in a situation where a union can force them into non-compliance with the later enacted statute, or in the alternative, file a charge against them under the National Labor Relations Act. But I will confess we have not run that to ground.
Okay. And I think it's also important to note that there's the reason that we can't answer a lot of the questions, detailed questions about the 2 paid leave mandates, is that this language was put together in a haphazard fashion. This did not go through the normal course of legislation, where there are hearings and when there's the ability to flesh out some of the practical impacts of the legislation as it goes through the process. We never had that chance. And so we're hoping that the attorneys that we have on Monday's webinar will give them these questions in advance and see if they may find some answers that we aren't coming up with just yet. I got a question here about please address how changes in the law may apply to ESOP companies identified as subchapter S corporations. Jimmy?
Unfortunately, our tax expert is not with us, so I can't tell you exactly how that would apply. I don't know.
I would offer that the statutes make no they don't distinguish what type of an employer you are, and so
absolutely not. It's just based on how many employees
you have. Right. And even coming up, I saw a question earlier, we have seasonal workers, do they count? And those are questions we just can't answer, because that would be something that we're going to have to wait for guidance from the Department of Labor.
My colleague Jim Young said it best, where this is a situation where the small contractors want to be big, and the big contractors are happy to be big.
Yeah.
Because they're left free. But the issue is, if you find a way where, if you're a wholly owned subsidiary and you start saying that, oh no, we're really part of this company or that company, you run into all sorts of joint employer issues. So, you have to be careful. Just because you want to get out of this requirement, what you do to try to do that might lead you into a whole new can of dirty water. So You got to be careful.
And please clarify, does the paid sick leave only pertain to sick leave taken on or after April 2nd?
On or after April 2nd.
Yes.
Yep. When it becomes effective. Yes.
Yep. Okay. Let's see. There was another question about how did they settle on 500 employees, employers with 500 or more employees being exempt from this?
We'll go back first. That threshold is normally a threshold that the SBA uses for various industries for determining whether or not they're a small business. The broader issue here is that the White House was saying that the vast majority of companies over 500 already offered these forms of paid leave benefits to their employees. So the focus was on the small businesses who did not, in order to get the protections to address this virus. The unstated political rationale would be that Ivanka Trump and then candidate Trump, one of their main campaign issues in 2016 was paid family leave. It has been an initiative that the president's daughter has sought to advance his entire term. And the way that they wanted to do it, they saw an opportunity, as Rahm Emanuel said, when you have a good crisis, don't let it go to waste. They are looking to do it now, and they had a victory in December in giving federal employees paid family medical leave. So, as you said, Steve, several months ago, that this was inevitable. We just never thought it was inevitable in a few short months.
Yeah, we thought we had some time to try to fashion a solution on paid leave, paid family medical leave that would have allowed employees to basically get an advance from their Social Security accounts and then pay that advance back by working the corresponding number of weeks that they took off for family and medical leave, work that same number of weeks past their scheduled retirement age, and basically replenish the kitty replenish the account for taking that leave. So it wouldn't be onerous on employers. So question, if the paid leave legislation sticks, well, yes, it will, at least until the end of the year. Do you see it as potential pass-through to owners?
Yes, but look at the time period for this right now. Look at the market we're in. It's, you're going to be fighting to find work. It's going to be very difficult.
Yeah.
I would add that it might depend on what's on your contract. So if you're working under a cost of work agreement, you're going to be in a much better position. If you've already set your GMP, that might be a different story. But if you've got a lump sum, it depends on what's on your contract, whether you can get an equitable adjustment for change of the law. Under consensus docs provision, you can get it. Under other standard documents, you would not be able to.
So here's a question I know the answer to, but I'll let somebody else give the bad news. I'm thinking of you, Mike Kennedy. At what point does the AGC, along with other industry associations, file a suit against the government to halt these decisions that are impacting all Americans?
Well, that's going to be a tough thing to do. Most of what we're seeing out there is being done at a state or local level, so you're not contemplating one piece of litigation. You'd be contemplating multiple pieces of litigation. Of course, we could mount a lawsuit against the new federal requirements for paid leave. The short answer to the question is at the point at which we think that this litigation would be successful and provide relief that we're going to need quickly. No one has drilled into it yet. I've yet to see a legal theory that persuades me that a legal challenge to the federal requirements would be successful, much less that it would yield relief within the 2, 3 to 4 months that we really need to get something moving.
Okay. Thank you, Mike. Again, back to the paid leave. If the Secretary exercises his authority to exempt companies below 50 employees, but then we still pay as a company with less than 50 employees, so basically voluntarily pay the leave, does that mean we will not receive the tax credit? It's a good question.
Good question. I don't have an answer.
Yeah. Yeah.
I might just chime in that, Congress passed this legislation very quickly. They didn't take the time to consider all the questions they were raising. Speed was of the essence. It's going to take time to get these questions answered. If Congress had taken the time to think through these things and the unique characteristics of the construction or any other industry, my guess is that it would have taken them months to get something out. So we have a lot of uncertainty surrounding this, and we're just going to have to try to get the answers as fast as we can. That's what Jimmy and the national staff will be doing on a day in and day out basis as we interact with the federal agencies.
This is a question I think I can answer. With the language, the effective date takes effect no later than 15 days after the effective date. Could it be an effective of today? I think the effective date is 15 days following enactment, which was March 18th, which means the effective date is April 2nd. Am I clear? Am I correct on that?
Yeah.
And then the question.
Trust me, I wish it were April 1st, just to say it starts on April Fool's Day, and this is all a bad joke.
Okay, I'm afraid you're wrong. Does this include hourly employees? Yes, absolutely it does. How does this?
Yes, it's the average of what they work in 2 weeks.
Yeah. How does this affect employers who laid off employees prior to March 18th? If they weren't an employee on March 18th, then they're not covered. Okay.
Correct. I have not seen if there's any clawback. As far as we know, this takes effect April 2nd, and I think this will be a great question for the lawyers on Monday.
Yeah. Is the paid sick leave on top of any existing paid leave? And the answer is yes, for now. We are looking to get some clarification from the Department of Labor on that. Okay. And question about on the paid family and medical leave. If you pay 2/3 of regular pay, if you voluntarily pay 100%, do you get credit for the 100% that you pay? And I think the answer would be no to that.
I agree.
Is the employee count as of the date of the pandemic? We are not in our construction season quite yet. I think a case can be made that the employee count is what your count is on April 2nd.
Steve,
Yeah.
this is Claiborne. It's actually for the paid sick leave. It's on the date. If they work immediately, there's no look back. For the paid family medical leave, they would have had to have worked for at least 30 days prior for the employer.
Prior to April 2nd.
Yes.
So somewhere around March 2nd or March 1st or March 3rd, whatever 30 days is. Okay. Can you please clarify the first bullet under some improvements regarding employers under 50 employees? Let me go back to that. Okay. Yeah. The clarification is that originally the 50 employee exemption, 50 employee or less exemption was not included in the original House legislation, and that got fixed in a technical correction. Okay. Are you aware of a model notice that has been published for HR 6201? No. If there was, we would have published it. We would have shared it with you. Okay. So then the question, I thought the 12-week federal paid family leave applied to 1, anyone diagnosed with COVID-19, 2, anyone caring for someone with COVID-19. Are those void now? The only criteria that makes an employee eligible for the 12-week federal paid family leave is that they are watching over a child who cannot go to school because the school is closed, or there is no available daycare. So those first two examples that the questionnaire listed here were in the original version, but we were able to knock those two eligibility criteria out of the final bill. So with that, I think we have exhausted our questions. I think we'll end this now. I will also remind everybody that this will be available on our website, or you'll get a notice soon allowing you to link to a recorded version of this webinar. So with that, I'd like to thank you all for participating. I'd like to thank those of you that have responded to our surveys and to our calls for action with legislative alerts. I'd like to thank my colleagues on the national staff for their continued hard work on all these issues. And I hope that you all can have at least a restful weekend. Thanks again, and we'll sign out now. Thank you.